Good afternoon, everyone, and welcome to the program From the War Room to the Bench, Navigating AI in the New Legal Frontier. For this webinar, attendees will be in listen-only mode. If you need technical assistance, please submit your request under the Tech tab located in the window on your screen. Someone will help you as soon as possible with any technical issues you may have. If you wish to submit a question during the presentation, please use the Q&A window on your screen. Presenters will do their best to answer your questions. However, due to the thousands on this program and time constraints, we will get to as many as we can. Throughout the program, there will be polling questions related to the hypotheticals that will appear on your screen. Please take a moment to answer the questions as they are announced when they appear. We'd like to hear from you throughout the program. We appreciate your participation in the short evaluations. The program evaluation can be found on your screen just below the handouts. To qualify for continuing legal education credit in certain states, please click on the verification pop-ups that appear on your screen randomly throughout the program. If your state does not require verification codes, such as Illinois, you are not required to click on these codes. A link to the CLE certification process will appear at the end of the program. This presentation is being recorded. A link to the recording will be sent out to all registrants in the post-event email and will be available on the Clifford Law website at cliffordlawcle.com, www.cliffordlawcle.com. The presentation will now be turned over to Robert Clifford, founder and senior partner of Clifford Law Offices. Bob?
Thank you, Pam. Welcome, everyone, and good afternoon to you. Once again, I'm Bob Clifford, founder and senior partner of Clifford Law in Chicago. This is now our 19th year that Clifford Law has proudly offered a quality program providing 2 hours of free professional responsibility credit. Nearly 5,000 lawyers are registered across 6 states in what we believe is the largest program of its kind in the country. I am committed, as I know each of you is as well, to raising the quality of the practice of law at my law firm and also throughout our state, as well as the others who are joining us today from, again, the 6 states around the country. And in addition to promoting the ethics and the quality of the practice, we also have had programs promoting civility and goodwill among the bar, and it's been a wonderful opportunity for us to engage in some very important topics that are germane to all of our practices. I hope that this program today achieves those goals and is another step in that direction. Today we present a very timely topic on artificial intelligence entitled From the War Room to the Bench, Navigating AI in the New Legal Frontier. At least for me, not a day goes by where I'm not presented with some AI something, whether it's a vendor promoting AI products or learning that some lawyer has done something inappropriate with his or her use of AI. So today we've got a wonderful panel to explore these topics. We're joined by 4 outstanding panelists in this area of law. The first being Professor Daniel Linna from Northwestern University, Pritzker School of Law, and McCormick School of Engineering. He's joined by Mark Palmer, Chief Counsel of the Illinois Supreme Court Commission on Professionalism. Then further, we have Judge Michael Camille, the Circuit Court of McHenry County. And then finally, we have Justice Theodore Wilson of the Cook County Circuit Court Chancery Division and the Illinois Appellate Court. You can learn more about their backgrounds on my firm's website, cliffordlaw.com. We encourage you, in the thousands who are joining us today, to ask questions. Everyone watching is muted, but you please have the opportunity to submit questions in writing, and we'll do our best to get to those and present them to you. Right before the program, I gave Pam an exercise that why don't we try to use AI a little bit on some of these questions to see if it'll help us at all with the answers. So we'll sprinkle that in along the way. Also, to increase the interactivity of this program, we'll be asking a series of polling questions after the hypotheticals that will appear on your screen. So please try to participate. We'd like to hear from you about those questions. So without further ado, I turn to our first hypothetical, and we will get to those in due course here. So panelists and folks joining in, the first hypothetical involves that plaintiffs file various pleadings before the court, which finds that plaintiffs' pleadings contain multiple citations that are incorrect. They do not contain the quotes or the content cited to, and reference cases that can't even be located. So the court asks plaintiffs to show cause as to why sanctions should not be levied against them. Plaintiffs assert that they committed various errors due to human oversight under significant time constraints. The judge made me get this done too quickly. They had to seek outside help. Their citation errors were immaterial and inadvertent, and there are no cases were fabricated, but instead they were misspelled or miscited, misremembered during the drafting process. Additionally, plaintiffs argue that there is no evidence of artificial intelligence use, as there are no systematic fabrications of errors. So let's ask our polling questions here and to the panelists. What is the most appropriate solution of this show cause hearing? One, that the court should close the matter without sanctions because there is no proof that plaintiff's counsel used artificial intelligence, or two, that plaintiff's counsel should appeal any court-imposed sanctions because they stuck to their guns and there's no proof that they used AI, or three, whether generative artificial intelligence was used is not material. That does not matter, that the plaintiffs provided the court with a litany of inaccurate information in support of its claims, and thus sanctions are appropriate, or the court should decline to use sanctions because there is no rule against using generative AI. Judge Wilson, what do you think about all of this? And maybe Mark Palmer, if you could jump in as well.
Well, as we all know, we have Rule 11, and each state has different rules with respect to signing papers. And if you sign your name to it, you're supposed to check it. You're vouching for this work. Everyone makes mistakes, and mistakes happen. However, in this case, it was really atrocious. This is PR Soccer League case, Federation of Puerto Rico, and the lawyers say, "Hey, we didn't use AI, and you can't prove we used AI, and so we did nothing wrong. It was just mistakes." Well, it was so atrocious. It was littered. I mean, littered with hallucinated cases and inaccurate quotes that weren't even in the case. And so saying that, well, you can't prove we use AI is of no moment. You have to have, you signed it. It's bad. And not only that, you have a duty to candor to the court. And clearly, you are violating the candor to the court. As a matter of fact, your excuse makes it even worse, because now you can't say, well, I'm sorry, I used AI and it hallucinated, I won't do it again. No, you're telling us you really intended to fabricate and submit fabricated information to the court. And so
Mark,
you weren't saved.
Yeah, Mark, I see you shaking your head, but I have to tell you, when I first read this one, I said to myself, I wrote a note here. What's illegal about using AI?
Well, Justice Wilson's right on point here, because I'm really glad you started off with this question, because I think we all have seen these reports in the news almost, again, on a daily basis, right? There's even a worldwide database keeping track of all these kinds of cases, some of them minor, some of them extreme, right? And it's right on point. It's candor to the tribunal, and we're going to refer a lot to Illinois rules, but a lot of them mirror the ABA model rules, of course, when we're talking about ethical rules, right? So candor to the tribunal here, 3.3. But the key point here, and you allude to it, Bob, this is not an AI issue. This is an accuracy issue. This has to do with, if you're signing on the dotted line, you're accountable for what you are filing, whether you're a lawyer, whether you're a self-represented litigant, whether you're a judge issuing the order, right? And I'm going to be repetitive throughout this 2 hours on a couple points here purposely because I want you all to drive this home. If you're taking notes, these are the 3 words I want you to write down: policy, governance, and enforcement. What do I mean by that? Well, if you have a speed limit sign, it's only as good as if you're teaching driving skills and competency and you're running radar to enforce that speed limit, right? So the policy is only good as the paper it's written on if you're having some type of office rules and guidelines and guardrails to follow. And that's a starting point. That's great. But at the end of the day, who's double checking your work before you file it with the court, before you send it to the client, before you submit it to opposing counsel, and so on? That's the starting point we're having this discussion around, is accountability within yourself, within your firm, your organization. So it starts with the policy, but it has to follow more than that. It has to define the tools and the training to establish the governance to build around that, the operational guardrails that follow that. And then you have to have enforcement of it, right? You have to have double checks on, is it being followed? And if it's not, you need to remediate that, solve those kinds of problems.
I want to jump in with one quick point on the that Mark made about the hallucination cases. And there is a growing database. I think I heard someone say there's 700 such cases. But one really important thing to understand is that the vast majority of these are lawyers using consumer tools, using ChatGPT, using Claude. Those are not the tools you want to use for doing legal research. If you use a tool from one of the major legal information providers like Westlaw, Lexis, VLex, you're going to have a much better chance of getting research. They have all the cases. They can use other techniques to check the existence of the cases. That doesn't mean those tools are perfect. Those tools can still hallucinate or get the holding of a case wrong or things like that. You still have to carefully check it. And you, as the lawyer signing the papers, are still responsible. But it's really important to understand the difference between consumer tools and tools specifically for lawyers to use for legal research or other legal tasks.
And Professor, thank you for that. Let me just say this though, that over 90%, I think 91 or 2% of our audience clicked in on, and they felt that the correct answer to the resolution was the court should close the matter without sanctions because there is no proof that plaintiff's counsel used artificial intelligence. But I want to go back to my question. What if he did or she did? What's wrong with using artificial intelligence to help you? Isn't it just a tool? It's not going anywhere, guys. I must have gotten 10 or 15 emails today from people trying to sell me artificial intelligence tools.
And Bob, that is the point of the question. The point is, it doesn't matter if they can prove that they use AI or not. It doesn't matter. You could use AI, but you have to check the work, and there has to be candor to the court. And so you have all these hallucinated cases. You can't find, it's littered. I'm talking about littered. It couldn't be any more telling. And so if you didn't use AI, it was even more egregious, in my opinion. And I'm not one of those judges who believe in sanctions for every misquoted case or even a hallucinated case. But candor and lack of candor to the judiciary, that is going to get you sanctioned, and that's going to get you reported to the bar. And so I think this question made its point, because it doesn't matter that whether or not you use AI or they proved you use AI. It doesn't matter.
All right. Fair enough. Let's move on to hypothetical 2. Little Engine and Could law firm. Now, by the way, Pam makes up these titles. I do not. I'm throwing her under the bus. We could have had something a little bit more creative. All right. Little Engine and Could law firm recently lost a workhorse junior associate who handled new client call screenings for the past 2 years. Learning that 79% of legal professionals are now leveraging Gen AI technology, the managing partner decided to revamp the firm's website to include a chatbot which analyzes online contacts for potential clients. So here comes potential client John Clueless. He used the firm's website to ask for the relevant statute of limitations for his accident, a car crash. Without any disclaimer or supervision, the firm's large language model advised John that the statute of limitations is 2 years. Seeing that he had more time, John decided to wait before hiring an attorney. So what are our polling questions here? What went wrong? Well, what went wrong, of course, is that the statute was wrong. It was 1 year, but now the potential client A never signed an attorney-client agreement. So is there nothing to do here? Do we see nothing here? Or B, the firm did nothing wrong because the potential client did not input his case involving a city transit bus? Or C, the disclaimer on the firm's frequently asked question page should protect them from any legal malpractice claim? Or 4D, the firm likely did not comprehend the capabilities embedded into its website. Judge Camille, what do you think about that?
Well, I think the firm is responsible. You know, Bob, what you put out there, it's got your name, my name when I had my firm, etc. And I put a note here that it's my top 5 or 3 pet peeves when somebody comes into my court. Maybe Thaddeus has had this experience too, more so across the street at the Daily Center, Thad. But somebody said, well, somebody told me to do this. Oh, wait a minute. Unless that somebody is Bob Clifford or attorney Jane Doe or whatever. And then, by the way, I know Bob Clifford, Jane Doe, they're going to be there. So, my question or my issue is going beyond that is, and I know, Dan doesn't talk to me because we started, well, no, we talked, Dan. Dan and I taught judges this stuff a couple years ago, and then ever since then, it's a firestorm. But, one of the questions is to what extent I believe AI should be regulated. And I agree with most. If it hasn't been said here, so I'll steal the thunder. AI won't replace an attorney, but those who use AI will likely replace those who don't. So here, bottom line, the regulation has to come from within the practice. You use that tool, you're responsible for it. And, if we're specifically asking what can you use AI for, I would say like the setups, right? The difference, like when I teach civics, the difference between federal and state court, or, how to, physically the Supreme Court in Illinois wants us to file things electronically. But as for the what and the when and the where, what I'll call particular detail, I think I got to, respectfully, Bob, I got to hear from Bob Clifford.
Well, I have some actually. Well, here, let me stick with the script here for a moment. Mark Palmer, what do you think about this?
Yeah, Judge Camille's right on point here. I think the two main takeaways here is the competency issue and the supervision. I think D. David is the best answer here, even though it doesn't discount the power of a disclaimer. Disclaimers are important, but here it comes down to Rule 1.1 right at the beginning on purpose. Does the lawyer have at least a general understanding of relevant technology to know the risks and benefits of using it? Here, they've chosen to use a chat bot on their consumer-facing platform, be it their website, right? So they are responsible for supervising that. That's Rule 5.3, non-lawyer supervision. That extends beyond human beings. That extends beyond to vendors, to even independent contractors. So you are responsible for your technology. And like Judge Camille was saying, that difference between information and advice, you want to stay real close and hold those reins tight to just sticking with the informational aspect, and you want to have those processes built in. So if you're utilizing this kind of tool, which is great, it's a fantastic tool, but you need to be transparent about it and careful that if you're getting closer to that advice issue, you're doling it out to a human attorney to exchange and engage with that potential client or actual client, right?
But here's the follow-up though. Why is there an attorney-client relationship developed simply because this gentleman got into a chat with my computer AI system? Is there an attorney-client relationship there now? Was a duty created on the part of the lawyer? Or can you absolve yourself of that by having all sorts of disclaimers? Don't ask for legal advice. We're not giving you any, and get a lawyer. I mean, how do you deal with that?
Bob, and
I think
we have questions coming in, and building on your question is, we have David asking, what about if you're integrating, the lawyer integrates with Westlaw resources? Would I be at risk of losing the work product privilege if it really wasn't my work?
Well, Bob, if I can talk to your point, I agree with you. Okay, and if you come to my website, look at the disclaimers. You know, you're not getting, well, not that you want Mike Camille, but you're not getting Mike Camille. You're getting a computer screen, but it has my name on it. When I was in practice, it has the attorney's name on it.
Right,
And
right.
I don't know, what are we supposed to say, Thad? You know, maybe we can't give
I
advisory
think
opinions, right?
exactly, but I think that's the battle you and your insurance carrier, your malpractice carrier, don't want to have. That's not the court case and battle and news flash with your name on it that you want to have. The key here again is competency, and you need to be aware of the systems that you use. And so where lawyers get in trouble a lot, as you said before, the professor said, they're using systems that they don't understand the full power of and how they really work. And so you have to be competent about these systems and tools that you're using. Maybe you get it dismissed. Maybe you have to go to summary judgment. Maybe you have to go to trial on this type of issue. Is that really where you want to fight and spend your time?
Well, you're right about that. But I also think that from a law firm operational perspective, if you're going to allow that kind of a chat, you should actually have a system in place that records the chat. And, you know, you tell people up front, this is being recorded. And then secondly, you preserve the chat and the response. And there needs to be an identified lawyer within your firm who on Monday morning is going to be reviewing these things to see if there, in theory, have been any professional undertakings assumed by the law firm because of what happened in the chat. You got to do that.
That's a great point. You know, I'm blessed out here, Bob. Everything in our circuit is recorded. So, you know, subject to review, right? If somebody says, hey, Camellia said something, I go and I listen, but you're spot on. I agree with that wholeheartedly. You got to keep that record. And maybe even look at it, right? Have somebody look at it periodically on Monday morning from the weekend. Anyway.
And even if you're able to avoid a lawsuit, look what happened to this person. You know, they're now waived and lost a possible valid claim, and you don't want that either, even if you can avoid a lawsuit or malpractice claim.
I have to tell you, from, you know, my perspective, running the firm that we run, I think the moral of the story is you don't have a chat that can give out any legal advice whatsoever or any legal anything. You refer them to the McHenry County Bar Association.
Right.
Yeah. There you go. All right, let's move on here. Hypothetical, Pam, unless you have a question that's worth talking about.
Can I interject, Bob, with a couple of questions that keep coming up from various people, Rachel and others, that my employer is employing the promoting the use of AI within Westlaw. Yet somebody said that their tech expert said that Westlaw and LexisNexis still have 30% of the time hallucinations. It's because of the way the question is asked. And AI is just always trying to make something up, so perhaps to please you. So then Rachel's asking, I'm hesitant to use Westlaw. Do you think it's safe to use more of this or do more research myself with a tailored search? And I think we have one of our hypos coming up touch on this, or would you want to touch on it now, some of the speakers?
I'll tell you.
Go ahead. No, go ahead, Justice.
Judge Thaddeus and then the professor.
The key that's going to be undergirding all of this conversation today is you're responsible for the result. You're responsible for your work product. You're responsible for checking it. So if you use a tool that's assisting you, great, but check it. So and what's the harm in checking it? It just took maybe 2 hours away from some of your research. At least now, before you finalize it, you can check it and verify it.
There you go.
Well, just one of the things that I wanted to add is that I think someone is referencing a study that was done by Dan Ho and his research group at Stanford. And they did some testing of tools from Westlaw, from Lexis. They compared it to GPT-4. And they did find a hallucination rate. I think it was for Lexis was 1 out of 6. There were hallucinations, and there was a little bit higher than that for Thomson Reuters. Now, this was rigorous research that was done but you need to take it with a grain of salt, because I think there's some criticisms you could have of that study about the way they counted hallucinations and the kind of questions that they asked. But I think we're quickly getting to a world where each of us who are using these tools need to know something functionally about how these systems work. And just to go back to what I was talking about earlier, if you're using ChatGPT, lots of cases are behind paywalls, or they're on state court, court systems where the ChatGPT can't get access to them. Claude can't get access to them. Westlaw, Lexis, BLX, they have those cases. So they can actually set up a system that allows you to access the cases that you're looking for when you train. When it puts out the name of a case, it can check a database and make sure that the case actually exists and give you a link to the case. These platforms can still make mistakes. Like if the holding of the case may be tricky, or the AI system may mistake what the holding is, or different types of errors that can be made. But I think we're going to have to get, Justice Wilson is absolutely correct. Judge Camille, Mark Palmer, they're all correct. We've got to check the outputs. But I think you need to also know a little bit more about understanding the system you're using, ask questions of the vendors, and understand what kind of errors are likely to result. And we're going to ask more and more, was the review that you undertook reasonable? And you can only answer that question if you know something about the system that you're using.
Dan, maybe someday in the 8 states that we're talking to, you might have computers. My colleague, Judge Alon Stein, asked me earlier on a presentation, if I seen chatbots come into my courtroom, I'm blessed. I still have a courtroom full of people and a Zoom room full of people, but that technology is there. And until we get there, though, I think it's simple. We got to slow down just a little bit. It's enough that somebody can zoom into my courtroom, and I welcome everybody. I have people coming from all over, but you got to slow down. Our reputations, right? And when you sign a pleading, Rule 137, Rule 11, 9011 in bankruptcy, critical. So anyway, I just wanted to emphasize that.
Oh, very good point, Judge. All right, Pat, let's move on to Hypo 3. A small firm deploys an AI-assisted intake form that asks new clients about their legal issue and then automatically drafts engagement letters and basic pleadings using the client-entered data. A client is confused about the engagement scope and mistakenly believes the form submission alone created an attorney-client relationship. Well, we're there, weren't we? How should the attorney ethically structure this process? 1, permit the AI to auto-generate legal documents and send them without review. Efficiency is paramount. Or 2, require all AI automated client documents to be reviewed and approved by an attorney before sending. C, allow the process if there is a pop-up disclaimer about attorney supervision or the lack thereof. And D, only serve existing clients, never leads from the public. Justice Wilson, what do you think about that one?
Again, we go back to this underlying theme. You're responsible. Review it. Use the tool. The tool is going to help you with efficiencies. It's going to probably create a better document, especially for those lawyers who writing is maybe not their forte. Use the tools. But you are responsible for checking it, and you're responsible for everyone, whether they're a lawyer, a secretary, for checking it. Would you let your secretary just send out something without you checking it? No, you don't let the AI do that either. You check it. Use the tool, but check it.
That's right. Mark, you agree?
This is almost a continuation of the last question, right? You've got the client, now you're doing intake, but you're still using AI, and that's great. But this goes to the governance section. I said policy, governance, enforcement. This is the governance. This is where you need to dissect your workflows and take a fresh perspective of them when you're bringing in technology, whether it's AI or not. It can be other technologies. That's great. The point is you have to be clear about it. And just like Justice Wilson said, it comes down to backing it up with legitimate checking. So just like you're filing something with court, now it's going to a client just the same. So you need to review those things because you have not only a should-do obligation, you have a must-do, a supervision obligation under 5.3 for non-lawyers and AI bots fall right into that too. So you need to dissect and go through the process to figure out where does it make sense to make efficiencies, but not going above and beyond. So I think I think there's the best answer that many of you chose.
Right. And to add to that, I mean, from a law firm operational perspective, I can't think of anything worse than to have an AI platform create a document that is not supervised by counsel. The idea that we all want to get automated, and look, there are all these lawyers out there. I don't know about your experience, but it just seems to me that law firm advertising is exploding at the moment. I'm not sure why, but those folks with all the intake that they're getting, I could see them using that kind of product and then sending it out. I mean, the opportunity for a mistake being made is just amplified all the more, and that's not fair to the clients that we serve. So don't go that way. There has to be lawyer supervision with these materials.
Bob, we have a number of questions, though. I'm sorry, Mark, and you may want to answer this. The panel is saying that an attorney-client relationship needs to exist in order for these formalized rules of ethics and model rules to still apply.
But Pam, what we were also saying to the person asking the question, we don't know when that attorney-client privilege relationship comes to exist. And there are cases, sure, there are rules, there are interpretations of the rules, but like Justice Wilson and I think said, and maybe we all have said, why would you want to, why would you want to run the risk? So that's the concern. If you have Clifford's name on it, Bob wants to make sure that he doesn't have that exposure. So I think that's the point to the person.
Bruce Papp says, as we all know, Bruce, he says, with no disclaimer, a lawyer's website alone giving advice allows the lawyer to be sued. Thanks, Bruce, for your input.
There we go. All right, well, moving along to hypothetical. I'm sorry, Mark, go ahead.
I think this is a great opportunity time to mention, I think it's in the resources, in Illinois at least, we have an ARDC has put out a guide that has addendums in that guide or attachments in the back of it that can help all of you do exactly this. So yeah, we're talking a lot about it, but when you need to become actionable about it, you say, I need a policy or I need guidelines on how to do all this. I need to figure out what do I need to ask these vendors to know if the data they're taking from me is secure and not going to be used to train models, etc. That ARDC has samples to talk about that and questions you need to ask, for example. So you can have some follow-up homework to do after these 2 hours.
Yeah, well, Mark, just to add on to that, and then we'll move on. I know of a firm, not a startup firm, but they haven't been around all that long, but they were rebuilding their website and really trying to make it high tech. And they then went to the ARDC website, downloaded all those things that you're talking about, because they thought that would really help them build the website to address some of the things like this, to be in compliance with it. And I thought that was a good tip that when, like, we're always looking at trying to refresh our website and bring it up to date. And I told the people, let's go take a look at what the ARDC is doing and saying, because those things may help us make it even better, all the better. I think that's just a good practice tip that maybe comes out of this discussion. So let me move on to hypothetical number 4. So during discovery in a complex case, a law firm uses an AI-powered document review platform to identify privileged communications and responsive documents. Later, opposing counsel receives a batch of discovery that inadvertently contains several privileged materials. The AI's privilege filter missed these things. I don't know, we're going to hear about this one. I think this is, okay, kind of straightforward here. But what best reflects the lawyer's ethical duty? A, the lawyer's duty of competence requires ongoing human supervision of the AI tool to avoid privilege waiver. B, the privilege was waived by relying on AI, so nothing further can be done. C, since the AI is slightly accurate, errors are an unavoidable risk and therefore excusable. D, the lawyer can delegate responsibility entirely to the AI vendor under a technology competence assumption. E, he better get an immediate clawback letter out there right away. Okay, so what do you think, Professor?
Yeah, so I think, Bob, you're alluding to, I mean, this is an issue that's been going on for a long time where there can be an inadvertent production of a document that is privileged. So you need to put people on notice right away. Please return this document to us. We inadvertently produced it. And if there's going to be a fight about it, there's going to be questions about what sort of human supervision was there, and what AI tool did we choose? Did we vet it? Did we check to see what sort of accuracy the tool has? I think that lawyers have been not too quick to trust AI tools for doing full-blown privilege reviews, but they absolutely can help. But you're not going to be able to just totally outsource that to AI. I don't think at this point in time. Maybe sometime soon you can, or in particular situations you might be able to, but you're going to have to show that there was human involvement, you vetted the tool, and there was accuracy. Otherwise, you're going to probably lose the fight over the waiver of privilege if you did not act reasonably in that process.
Is by using that tool, whether it's on this application or even in some of the previous discussions we had, are there any unauthorized practice of law issues taking place by using all this AI stuff, or are we allowing AI to practice law?
I don't think there's a problem in terms of unauthorized practice of law if you, the lawyer, or a lawyer, is properly supervising, reviewing, and checking the work. It is an assistance. You don't say, well, Lexis or Westlaw is engaging in the unauthorized practice of law. No, you are responsible for doing the research, using the tools, and checking and double checking the work.
Got it. I agree.
And you're gonna develop the prompt, and I think that's where we as lawyers use AI. And if you're gonna spend money in this area, one of the spots is prompt engineering, because it's how you're driving it. But that's an interesting question that I think is going to continue to evolve.
Well, Judge Camille, you raise a really important point, because I saw a few people grumbling a little bit about the accuracy of some of these platforms, and certainly understanding how to use them, learning how to prompt, and what things they do well and what things they maybe do poorly. Those are really important questions. The unauthorized practice of law question is really interesting, because you look at some of the things some of these platforms do. Early on, ChatGPT would say things like, "Oh, well, you should see a lawyer. I can't give you legal advice." And then, it got to the point about a year ago where it would ask me something like, "Oh, well, do you just want a general answer, or do you want something you could file with a court?" And so it kind of looks to me like it's giving me legal advice or creating legal documents. But I don't know how quick people are going to be to want to have that legal fight with these multi-billion-dollar companies.
Yeah.
And,
go ahead.
If I can add on, Bob, one of the practice pointers I like to give, some of us like to give when we talk about AI, is what AI can do, and just ask ChatGPT this question, right, Dan? Maybe I've used this as a presentation. One of the things it does is it helps us with timeliness. It gives us a lot of horsepower quick. But here's my add-on, my practice pointer. No, like Dan just said, know your system. Competence rule 1.1, critical to the practice of law. Very proud of that. Hey, I'm not going to go down that path if I don't know it. But here's the add-on, the practice pointer. Be careful when a judge respectfully is asking you, well, how much time is it going to take you? If it's going to take you a solid 30, 60, 90 days, then say, Judge, I need this. Because, it's on you. And don't say, well, I can get this done overnight. If you do, you're beholden to the tool and what you're giving to the other side and the court.
We have a question about the unauthorized practice of law if a chatbot is set up by a non-lawyer that answers legal questions. Do any of you have any comments? Because you guys were talking earlier about the unauthorized practice of law.
I think a lot of depends where the lawyer supervision is at. I mean, go ahead.
I think, again, not many lawyers have the technical skill to create some of these products and prompts. Matter of fact, a lot of schools are giving certificates now that the students can get for prompts and doing this type of research. So of course you may have a non-lawyer drafting and creating these tools. You're still responsible for reviewing, editing, controlling, and monitoring the use of those tools and the output of those tools to clients or potential clients.
Right. So, I wanted to go back to the actual, some of the questions though about the AI production and the fact that documents were sent out that shouldn't have been. One of the exercises that we recently did at the office is on a case that was closed, is we used an AI tool to identify what documents should be produced in a case, and we compared the outcome of that with what we actually did.
Wow.
And to see what the difference was. And I think it means we got it right, but the tool got it right because there was virtually no difference at all, which was terrific. Because once again, we're getting hit all the time with these potential, vendors that want to give you stuff. And in some of the cases that are, people on the participating today are handling, you could easily get $1 million pages of material, let alone, hundreds of thousands of documents, and then multiply that by the pages within them. Going through all that stuff is just enormously, expensive. And if AI can help you with that, then more power to the product, right? So.
Bob, to your
Okay.
first point, though, somebody's asking about pro se clients. And if you're representing or even up against a pro se client who used AI, and you later represent them, what are you supposed to do if they come to you with AI materials, or clients or potential clients that have already gotten information, legal advice, quote unquote, from a chatbot?
I think we see that in the courts now. It's both a blessing and a curse for litigants. I almost to the point where I'd rather them have and submit something created by AI and me have to then sift through it than them not to give me anything. But let's take an example of going to the doctor. What do the doctors hate now? Oh, well, WebMD and Google, and people come in with everything that they've searched and they bring it into the doctor's office and self-diagnose with this and that particular thing. Well, we don't want to take that away. Bring it in, but monitor it, review it, and see what fits and what doesn't.
There you go. Makes sense to me. I take it, Judge Kamel, you agree?
No, I absolutely agree. And currently, after my role as chief, I brag about how I was the busiest call in the courthouse. I'm handling a lot of collections, and like Justice Wilson, we welcome it. And by the way, if a judge asks you, like I asked this one, we call them self-represented litigants, by the way, of course. But
Okay.
don't be afraid. And this one person, he was from Ukraine. He had phenomenal pleadings. And he said he didn't use AI. I was intrigued. But no, I think it's helping. And what Justice Wilson said is absolutely on point. Is it a blessing or a curse? And I think it's helpful. But like anything, and one thing, Dan, if you don't mind, I'm going to push back on one little thing. I usually don't. I respect you so much. But I think you could use stuff like, the free version for those on fixed income. Anyway, ChatGPT, it's a good starting point. Use it and, play with it, like my friend Dan taught me to use in an educational setting. And then that gets you down the path. But yeah, with self-represented litigants, I think it's generally good. It's providing what the Supreme Court is big on, and that's access to justice, whether it's our Supreme Court or just about any other.
And I've been testing out Copilot just to see, what it will create. And I tell you, it's pretty good. It can give you some great prose if writing isn't your forte, and it can create some wonderful documents, but it can also create some hallucinations. But if you go through it and review it, then you can throw out the trash and still have a very good polished product to submit to a court.
Okay, well, fair enough. Hey, Pam, by the way, there's a young lawyer, Lisa Dana, is having difficulties logging in, and she's worried about the fact that the system may not recognize that she's here.
Yes, they're working on it. They're working on it now. And I have a question if you wanted.
Yeah, by the way, here, pause, Pam, pause. So folks, if anybody's having tech problems, please let us know, because we'll make sure that it's reported that you participated in this program. Okay, Pam, go ahead.
Okay. Yes, we have a whole team that's working on any questions like that people when they have technology problems on the
All
program.
right, fair enough. All right, hypothetical number 5. Okay, folks, an attorney is preparing a discrimination case and learns the opposing party's hiring decisions were heavily influenced by an AI-based resume screening tool. The attorney is considering challenging the algorithm as biased. However, the court seems skeptical of black box AI arguments and wants concise, credible expert support. Dan, Professor Dan, where would he get it? What's he to do? Is the lawyer? What is the lawyer's primary ethical obligation here? Is he to decline to raise the AI discrimination issue since it's could be too speculative, or should he adequately investigate and, if supported, present the AI bias issue with appropriate expert testimony? Should he assume the court will not accept AI-based arguments and focus only on additional discovery, or file the claim as is, trusting the court to raise concerns about algorithm bias?
He's got to pursue the claim. Matter of fact, there's been some cases decided more recently where courts have found, denied the motion to dismiss the workday cases for discrimination in a case like this. So even if the judge is skeptical, there's a legal basis for a claim here potentially, right? So the lawyer's going to need to look into it and figure out a way to present it to the judge. And if the judge doesn't accept it, then you're going to have to take your shot on appeal. But I don't think the lawyer can't just ignore the possible claim here. And there's growing case law to suggest that cause of action like this could be brought.
Well, we're going to have an example of this later on. I want to say when we get to number 11, an analogous thing about built-in bias. Could maybe Judge Camille, have you had the experience where you see AI bias baked into the system or the tool?
Well, arguably, there's a bias. I'll say, Captain Obvious, maybe. There's a bias in every system. It's who's designing the algorithm, who's designing the system, what's it using. And, as you know, Bob, I'm sure you've won a few cases, or God forbid, lost any, where an expert was critical. And what are we looking for in an expert? Respectfully, I don't know if I want to say this. I'll let experts in. We love experts. Why? They help us, but they shouldn't confuse, or they shouldn't really tilt the scale. And here's an area, just as an extension of this discussion. Okay, I'll bring in the reference to deep fakes, and boy, you talk about a nightmare because they're tough to detect. But if you have two parties, and we look at, or we should maybe look at, and this is where I'm on the fence, look at the relative resources. If somebody can say, hey, that video is balderdash, then, does the other side have the resources? Balderdash is a word, balderdash, I apologize. Bologna sausage. But the point is, yeah, I think, to me, there's probably a bias in every system, but my judicial philosophy is I take what comes before me. I'm the steward. Right. Sure, I have an important role. I want to keep the case between the ditches. I want to respect everybody's rights, but I'm generally going to let you all present your case within the limits and parameters of the law, although I am concerned about that, unequal, the unequal set of resources. But that's the world we live in, and I think that's the beauty and part of our system.
And I believe people don't understand how recruiters and job employers are using AI to weed out hundreds and hundreds of resumes that they're getting for it. So I hear things like, if there's blue text, the AI is going to throw it out. If it doesn't have certain buzzwords related to the job, it's going to throw it out. And so all these things that are in there could, some of those mechanism could be a bias. I've even used Copilot to test the theory and say, I create a resume for this particular job, this employer, and it'll create it, and it'll have the appropriate buzzwords. It'll take out the blue text and italics and all these things that I hear AI bots are using to throw out resumes.
But Thad, there's just a second, man. Thad, there's nothing necessarily wrong with that, unless you're saying, hey, throw out all the people from the south side of Chicago. That should be absolutely illegal. But you know what I mean? What do you think about that? You can use it, but then the trick is, how do you get to those questions?
Right.
Maybe through discovery, right?
Right. I agree.
Pam, go ahead.
Well, to your point, Bob, about having AI generate questions here, I did filter one of the questions through chatbot, and it is directed to Judge Camille about if AI is now necessary to manage, as you were talking earlier, Bob, large-scale discovery. Will courts mandate uniform AI readable production standards to ensure meaningful access to evidence? And that was run through chatbot to give it to everyone.
There you go. There you go, Judge.
It was originally Judge Camille, but others can answer it as well.
That's way above my pay grade. Maybe even Justice Wilson, right? No, I mean, that's an access to justice issue, but, and it goes to my point about, inequitable resources, let's say, and, the seven, lovingly, respectfully, the Supreme Court justices that steer our ship, they're looking at this. Chief Justice Neville, those of us who are on the task force of the court, he showed up. He was our liaison, so he has focused quite a bit on this stuff. And I know the court is working with this, but that's a great question. And I'm not up to snuff, Dan. I would point to, or Mark, on deep fakes. I know there's evolving technology with the way videos are presented, and you can dissect and look at while in the dark ages, right, a few years ago, we used to call the metadata. And I think that's more and more coming online through detection tools to get at those deep fakes. But boy, that's an interesting question. I love it. And maybe one of us will write to the Supreme Court about it. But that has a cost component, doesn't it? Yes, it's a rhetorical question. So I love the question. Right. I don't know how to answer it.
Okay. Professor, anything to add to that? Otherwise, we'll move on.
Right now.
All right. Pam, let's go to hypo number 6.
Okay.
A firm adopts an AI-powered contract drafting platform, which includes a fee estimator. The tool gives potential clients quotes based on case type and details. One such quote projects that only 1 lawyer hour will be needed to complete the project. Given this projection, the client retains the firm. However, the actual billing varies significantly from the estimate. The firm debates whether to bill the client the saved hours or pass along the reduced cost. So there we go, hypo. What is the most ethical billing practice? Bill the client for the work as if it took 5 hours? Lawyer efficiency shouldn't reduce revenue? Bill only the actual time spent and explain the use of AI if asked? Charge a flat fee reflecting value delivered rather than the time saved? Or bill as usual while noting the AI tool in the invoice to justify the entries? That's all seems, I don't know, seems pretty straightforward to me. What do you think, Judge Camille?
Well, what's the value? And, early on, coming out of law school, worked for a judge, a bankruptcy judge, Richard E. Gunther, God rest his soul. And I got to review a lot of fee petitions, hundreds of thousands of dollars in line items. And, simple inquiry, was the time actually necessarily and reasonably incurred? And then a couple quick anecdotal references. There was the former dean of the bankruptcy bar, Ken Ritz, God rest his soul. He once, I remember he had a $25,000 bill. This is like 30 years ago. He tore it up and told the client, pay me what you think you owe me. Again, value. Then I could talk about another colleague who's passed, Dick Sikowski. I worked with his firm and with Dick. And, he once sent a bill, as the story goes, with feet upon the desk, a line item for services rendered, $5,000. Client told him, Dick, that was the best money I ever spent. So the point is, value. What's the value? I think the key is in the representation to the client. If you're telling the client that I spent 42 hours on this, or that's okay, let's say 42 hours at $200 an hour. Okay, and if you only spent 20, half that time, you're misrepresenting to the client. Instead, say you spent 21 hours at $400 an hour, because you're getting, that's the nature of my billings. Some of us may remember years ago, right, when legal research used to come online, factoring in Westlaw and Lexis charges. I remember in the bankruptcy court, were those allowable or not? It depended on the relationship established. Then ultimately, what does the law of most states say? Reasonable. Was it reasonable? And then I had those other two actual.
But isn't this also just a matter of contract? I mean, my deal was my deal.
Absolutely. No, absolutely. And that's where you have, I think in most of your cases, the best model. Hey, I'm going to take a percentage, and then, it's up to me to make it happen. I love that. It's easy, right? But no, you're right. What's the agreement?
What is the agreement? And it matters. I also think, but by the way, here's an interesting question that I know is out there, that there's been a suggestion that ultimately, if a lawyer doesn't use AI in her practice, it's actually going to be an ethical violation, because you're not really putting your best foot forward. How about that one? What do you think about that? Yeah, Mark Palmer, what do you think about that? Or Professor, go ahead.
Well, I just want to follow up on this, the previous one, that, so one of the rubs here is that if AI helps make you more efficient, then how do you bill your client? You can only bill the hours you work, right? That's the bottom line. So if something ordinarily would take you 5 hours, writing an intricate demand letter, but now you can do it in 2 because you use AI, you can only bill the client 2 hours. And one area where this came up in the ABA ethics opinion 5.2 is 512, a lot of people are moving now are trying to move to fixed fees, right? And one of the advantages of fixed fees is if you can be more efficient, you can have a larger profit margin. But there is some cautionary language in 512 to suggest that if you have a large savings, maybe something the parties wouldn't expect, you may have to rethink even your fixed fee agreement. It's not 100% clear exactly how that works, but that is something that you're going to have to think about. And to Bob's point, absolutely, I think we're going in the direction, and you can just think about e-discovery right now, right? If you're in a big firm and we're talking to 1 million pages of documents, if I put them in bankers' boxes and I sat associates around billing $1,000 an hour to review pieces of paper, boy, I don't think that's going to result in a reasonable fee. We got technology that can help do that, and more we're going to have technology that can help do things at a lower cost, still reduce the fee. And then the other key thing to consider here is that it's going to make it more accurate. And so reviewing contracts, due diligence, can using AI not help you just be more efficient, but help you do a more accurate job, do a better, higher quality job at the end of the day.
Well, but
the other side of that coin is, Judge, hold on. The other side of that coin is, there are a lot of lawyers who believe that AI is known to be inaccurate, and if you're going to have to just look at and review everything, then why are you bothering with it?
Right, and we have
here's the thing: it doesn't matter. It doesn't matter what the other lawyers believe. We live in a world where evidence rules the day. Okay, and that's what happened with technology assisted review. There was research done. Lawyers said it's not accurate enough. Well, then there was research done that found out when humans review documents, our inter-rater agreement is only about 0.7. So so if we both review the same document, we'd only agree about 70% of the time. AI only needs to be as good as the humans doing it. Humans aren't perfect either, so we'll have more and more evidence of data. It's not going to be better than humans all the time. The best is the combination of the human and the tool, but we're seeing more and more evidence that absolutely these tools can do better than humans at certain tasks.
Right. Who today would hire a lawyer that says, I only do my legal research in the library with the books? That lawyer is not efficient. That lawyer is not competent. You wouldn't hire that lawyer who says, I only use the books to do my research. I don't use computers. I don't believe in computers. No.
There you go. Well, I think that's Point well taken, Judge. All
Bob,
right.
if I could chime in, it's a sobering point, somewhat personal. A couple know this story, but I lost a spouse to a glioblastoma. And halfway through the treatment, we got routed to a guy at Northwestern, Roger Stoop, great guy, and we couldn't factor her into a clinical trial. But had we used AI like they showed in a 60 Minutes program on using AI in medicine, we might have found that treatment. And the same thing here. We want to get it right. So to your question, very perceptive. If we don't use it, is that a problem? Maybe. And I only throw that out there because I think, well, anyway, but thanks for that opportunity.
All right. Thank you, Judge. Okay, Pam, let's move on to number 7.
Okay.
There you go. So a solo attorney uses an AI tool to generate regular blog posts for their firm's website, describing recent case wins and legal updates. The attorney glances over posts before publishing, but doesn't always verify each fact, the client outcome, or the claim. Some posts inadvertently exaggerate case results and attributes wins to the firm that actually predate the lawyer's involvement, or I'll add, or the work product of other lawyers who are not even with the firm. Okay, so that said, what hypotheticals do we have? What is the most ethically sound strategy for dealing with this? You publish AI generated content without edits because it streamlines marketing, or B, you carefully review and fact check all AI generated content before posting, or C, you rely on a disclaimer stating the content may contain inaccuracies, or D, you delegate responsibility to the AI vendor since the tool was advertised as law firm compliant. Well, these are all kind of very interesting questions. I was wondering, Mr. Palmer, what do you think of these?
Well, I think B-Boy is the best answer here, and I think we're going to see more and more of this happening as technologies make it easy for us to create more ways to advertise our services as lawyers, right? We see more people writing blogs, and not just on a blog website, but posting it on social media, making videos. It's just so easy to do in a matter of minutes, and let these tools and agents of AI do it for us. But that doesn't just stop there. Just like the filing in court or the submitting a document to a client, just like this, what goes out our door follows under the Rule 7s in the Rules of Professional Conduct, the advertising rules. They must be truthful and not misleading, right? And so you have to be very careful, and you're going to have to review all those things. Just a reminder, we talked a lot about at the top of the hour about hallucinations. Hallucinations aren't just about the case citations themselves. They're often about the facts built in. So a case, for example, may AI may reference a case and get the citation right on point, and you may gloss over that, but maybe it applied the finding of that case completely backwards. So it's applying the facts wrong. The same can happen in a blog post, in other types of promotional items put out there. So again, it comes back to truthfulness, communication in advertising particularly, and your responsibility to be in honesty as well.
Got it. Mr. Palmer, anything that you could add to that? I mean, what are the concerns here about? I mean, the idea that anything AI generated would go out as advertising for your firm without being reviewed is just unthinkable to me. I mean, this is not like we're in a profession where we're selling washing machines and a little puffing is okay.
Yeah, I think the best practice here again is to create those playbooks for you on how you're making this process happen. It's great that you're doing it. You're applying the technologies, but you need to have an established process of review, of development, of publication, of then follow-up later. There's so many assets to it and elements to it that you are responsible for as a lawyer because we have these ethical rules that we must follow, and you don't want to trip yourself up. And you need to have those qualifiers built in as well. For example, the results not guaranteed, or all all things, results are dependent on your case, and everything's unique. All those kinds of things need to be existing as well. At the same time, they're generating something anew. So just as you review a non-lawyer or an associate attorney drafting these types of materials, you're going to be doing the same.
Yeah. I can't help but think that the analogy that I draw often, I don't know about all you, but like I actually use on my iPhone the dictate function, and I've had to really discipline myself to read the dictation, because the dictation gods sometimes like really say bad things that I didn't say. And yet if I just hit the send button after dictating it, I'd have a lot of bad messages out there.
Bob, the other, well, I was going to comment, I agree with you. And I'll dictate into Siri and send myself an email is the way I do it. But I go back maybe again to the dark ages, starting to date myself, when, there was a big debate to what extent a lawyer can even advertise, or you're just showing, availability. And I, like you, when I drive south or east, I see a lot of billboards, and that's fine. God bless, courts allowed that. But I think you have to be careful when you go out on your skis. And I'll say this politely to you and to some foreign partners. I like a little bit of a different approach, on marketing, and I write down a mantra: performance produces. They'll find you if you're doing well. But if you're going to go out on your skis a bit and really be vocal and ask for those files, you really got to be careful. Because it is all about the consumer, the potential client, and ultimately our system great system, love it. We're self-policing, and we got to be careful.
Yeah, that's the key point, Judge Camille. These rules are defined to protect the consumer, so you got to start and end with that mindset.
Yeah.
Well, there you go.
Questions here, Bob, and
okay.
I touched on it about, should clients be asked to sign off on when a lawyer uses AI? And then we have an interesting question from Matthew, who says, do clients need to be told to not type their communications with their attorney into their personal AI, because that may turn the communications into unprotected attorney-client communications?
Well,
I can answer that.
Go ahead. Okay, go ahead, please.
On the second point, there's actually a case just this week out of New York where a judge, a client went rogue and looked up cases on their own, and it was ruled it was outside of client-attorney privilege and confidential work product. So you have to be very careful. And I think that the jury's still out on how that's going to apply, whether you have an attorney or don't have an attorney. But the point is, you've got to have protections in place from the get-go on what you're doing to find that information and how you're delegating it to your internal processes and your external communications.
I took that question, though, maybe a little bit differently, Mark. I thought that question was that if the client was using AI to help generate her communications with her counsel, so let's assume that's the example, that a client is using AI to better communicate about her injuries.
I think,
does that somehow waive privilege? Go ahead, Judge.
I think that's going to have to percolate up, and we can't give any advisory opinion. I doubt that alone and in and of itself would be giving up any privilege. But what people don't understand is some of these products are training their large language modules with the data and information that you put in, and so you could give up some privilege unexpectedly by putting it in these systems, and those systems then spitting it out as an answer or response to someone else.
Well,
yeah, I think, and I think, go ahead, Judge, please.
No, Dan, I'll defer to you always.
I was just going to follow up on the case out of New York. I think Mark summarized it quite well, and I think it comes down to the confidentiality question, and that could come down to which tool they're actually using as well, right? And I also think, this was like 10 years ago, we had this big debate about the cloud, right? You couldn't put things in the cloud, it was exposed, but no, we're comfortable with the cloud, and most bars have signed off on it. And I think we'll get more and more comfortable with people using these tools. But at least right now, in the default setting early on for many of the tools was that your data was not confidential. It could be used to train a model, right? So it's just a question: did you act reasonably to protect the confidentiality of the information? And if you're asserting privilege or work product and you didn't act reasonably to protect confidentiality, it's going to be a waiver.
Well, and to emphasize the point, a couple of us might be involved with a certain bar group that a concern was raised early on to even engage or allow somebody to engage the AI note-taking function in a Zoom room. And the reason why, and what people sometimes lose track of, is when you're using most of these tools, ChatGPT, it's going up into the cloud. It's being dispersed everywhere, and it's lacking in confidentiality. So that's the critical mass. To what extent is the communication internal or through email? Email, you're going over the internet. But to what extent that communication has those protections in place? If not, then I agree with Justice Wilson. Boy, those are cases coming down the pipe. You got to be careful out there, right?
So I wanted to go back to the first question that Pam raised about whether you need client consent to use AI. And I think, this too, we have to break this up into, there's the questions about accuracy or how the work's going to get done and confidentiality. And I think the rules are very clear that if confidentiality is put at risk, you need the informed consent of the client, right? But now many of these tools, you can address this issue. You can get a tool from a vetted provider that you can ensure confidentiality. That's not going to be an issue. I think the other part of the question here is if you're doing something where maybe you're not sure about the accuracy of the tool, right? And I talked about using AI tools for contract review. That might be a conversation you got to have with the client if you want to use that. It could implicate billing as well. But I think, and I'm interested in hearing the judges' responses on this. And Mark, I think they probably know the rules better than I do on this. But, generally speaking, you think about the means and the ends. The client tells you like where we're going, and the lawyer has a little bit of leeway to figure out how to get there. But one of the things here that's tricky is if it's not the kind of thing that it's well vetted for using AI, then it may be, something you need to talk to your client. And I think as a practical matter, you should be talking with your client about this anyway, because if you're using AI, you can demonstrate like, hey, I'm doing this for you. I'm helping provide additional value in what I'm doing for you in this representation.
I think it deals with what are you doing with their information. You wouldn't have a situation where the client tells you can't use Lexis or Westlaw to do research. That's not their purview or prerogative. However, as you said, when it comes to their data and information and potential disclosure of trade secrets, etc., yes, you do need permission as to how you're going to use their information, their records and data to make sure that they sign off on it. I had a lawyer to tell me, well, it's those free services that's the problem. I only use paid services. No, that's not going to absolve you. Just because it's paid doesn't mean it's perfect. There are problems and issues there too, and you have to read the fine print and the privacy statement and the contract in terms of the agreement.
Yeah. Let me jump in here right at that point. From the practice perspective, I think the idea of using or not using AI is just part of one of the many tools in a lawyer's, bag that he or she is allowed to use. I really don't believe I need a client's express permission to use AI. Maybe someone will correct me on that and disabuse me of it. I do believe it's necessary to use. So, for example, on this hypothetical, over 95%, 7% of all the people who answered the poll believe that you have to carefully review and fact check the AI generated content before posting anything. So I think a common theme of at least the practice responses we're getting from the audience is that there has to be lawyer engagement in every time that AI is being used on behalf of a client, where the client's positions are being expressed by the lawyer. And going back to that one question about the time issue and the billing of it, I omitted, the majority of people overwhelmingly thought that the lawyer should be only billing for the actual time spent in using the AI. So, maybe even though the lawyer might have spent 6 hours, he committed to one and said he could do it in one. And that's his problem if he lost out and lost a little money on that case. But, and then finally, there's discussion about a client using AI to communicate. We've actually been receiving some things like that, where we might ask a client, I'm saying hypothetically, I want to disclose all of how Clifford Law does things internally, because some clever defense guy might now send me a discovery request. So this is only a hypothetical, but you might have a client want to write a memo to counsel that explains their case to you, and you use the information they give you as in conjunction with reviewing, let's say, all the records, and see if the client's version of what occurred is consistent with what's in the records. But some client might need AI's help in verbalizing their, what they are trying to communicate. I don't see how that waives privilege or anything like that from a practice perspective. So if any defense lawyers are out there and they want to ask that request, bring it on. We're going to have a fight. Okay. I'm done. Hey, Miles Bierman, are you out there? So my buddy Miles Bierman, he's there. He's been the longest. He's number one. He started the best, the domestic relations family law practice in the world. And Miles is still taking CLEs into his 90s. I ratted you out here, Miles. I told everybody how old you are, but he's still engaged, still goes to the office, and we should all be like Miles. There you go. Okay, new hypo, Pam. Hypo number 8.
Yep.
All right. A solo attorney uses an AI legal research tool that asks for a client's file uploads to provide tailored research memos. The tool is web-based, it's operated by a third party, and does not clearly state whether uploaded content will be stored or used to train the AI. What is the lawyer's primary duty before uploading client documents? I think we just heard Judge Camille refer to that. 1A, proceed immediately and client benefit outweighs any risk of disclosure. Or B, investigate the tool's privacy, its storage and data use policies, and obtain client informed consent if needed. Or C, only use tools that guarantee no retention of client material. Or D, rely on AI vendor assurances that the tool is secure. Those are all very interesting possibilities. Well, Judge Camille, I think you brought up the cloud. What do you think about these things?
Yeah, I like B. I mean, the fact of the matter is, like we're saying, you want to use AI, but everybody has to understand what that involves. You could use some elements of AI, generative AI, of course, we should always say is what we're really talking about. AI has been around for years, right? Decades. But, if that tool goes out into the World Wide Web, the largest language model, let's say, then yeah, that's where I think, Bob, you want to, let your client know, hey, I'm just so you know, like everybody, we're using AI, and maybe I'm going to do X, Y, or Z to let them know, tell them, but B is a great answer. Investigate, know what you're dealing with, and then to the extent necessary, if you're going to go again, we'll say into that largest language model, then get their consent, or they might say, hey, this is I think I have the formula to, pass up sliced bread. Isn't that what we used to say? The next best thing. And they might not want that anywhere. And then, okay, well, it's cumbersome, but that's the client's desire. So that would be my thought on this.
And 87% of the audience agrees with you, Judge, that it's really B, investigate the tool's privacy and storage and data use policies, and speak to the client in terms of informed consent if need be. And the remainder thought that only use tools that guarantee no retention of client material. But I don't know if that tool exists. In fact, Mark, have you all, haven't we all learned in this terrible thing involving Mrs. Guthrie in Arizona that people thought there was deleted videos from their doorbell cams and and Google is finding it for the police, and they're resurrecting stuff that people would have thought was long gone. Is anything really ever deleted, you know? Mark?
Yeah, this is it sort of really reminds me of the cloud when we were, just to, like, what was it, a few years ago when we were trying to vet what makes a good cloud vendor. We're looking at kind of that same reasonableness standard under 1.6. We have a duty to protect that confidential information on how it's stored, how it's transferred, how it's retained, how long it's retained, etc. We're doing the same thing again now for these AI tools. And that's where, again, I'll reference the ARDC's guide. Please take a moment and pull that out and look at it, because that's exactly why it was written, to help us with that evaluation, because we're just lawyers. We don't have that background, that technical skills anywhere near like what Professor Lena has or others. But we at least can have a starting point, a checklist to start with, and do what's reasonable to rely upon the vendors to show us the way. And so usually it's going to start with enterprise software, not just public-facing tools, but it doesn't just stop there. We have to ask questions about zero data retention policies, ZDRs, things like that. You at least have to have a working knowledge of what that means, why it's important, and why we can start relying on these tools from the get-go. And then we have that assurances we can give our clients on when we are using them, that we've vetted them properly.
Yeah.
Okay, good. Who was about to speak? Judge Thaddeus, Judge Wolf?
Yeah, even on some of the, I apologize, some of the committees that I was on, I've been on for the Supreme Court, E-Advisory Board, et cetera. And as the court started to gear up to more robust tools, we had to make sure, well, where's this data stored? Who owns it? Is it only stored in servers in Illinois? Is it stored in servers in another state or country that maybe someone could subpoena it, and the Illinois Supreme Court not have total control on blocking them from getting it? So those things also trickle down to law firms when they're using these tools. You got to know where it's stored. You always are under the assumption that nothing is ever deleted. Delete just means it's hidden away, but not necessarily that it's gone.
So another issue I'd love to highlight here around this is that I've been hearing more and more from lawyers that their clients are taking work product and then running it through AI tools to double check their work. And so if you write a memo for your client, it's attorney-client privilege, and they run it through ChatGPT to check your work, you should tell them it's not a good idea to do that, because you could, in fact, blow the privilege. Now, at the same time, I agree with Judge Camille completely that there absolutely are use cases where you can use ChatGPT, and I think we have to be careful about not over-rotating on confidentiality issues. If I was getting ready to file a brief in Judge Camille's court this afternoon, I don't think I'd be so hesitant to run it through ChatGPT. I mean, I'm going to file it on a public docket. Is there really something in there that's going to get me in trouble if someone says that could have been used to train an AI model? I mean, you just have to evaluate each case, I guess, and figure that out. But I think that one of the key takeaways here is just understanding where that information is going when you're using these different tools. That's on you.
I think I've heard lawyers are using products like Lexis AI Plus to upload the briefs of the opponents and to run it through, check if there are any hallucinated cases, check whether or not quoted remarks are accurate, and to see if those arguments or cases have been used in other briefs. I've even heard story when I was in Chancery that when lawyers would get the judge's ruling, they would run it through products like Lexis or ChatGPT to help them write the motion to reconsider. And so, sure, you can use those tools if you know what they're doing and where they're storing your information.
There you go. Okay. Look, I think we're all learning. This stuff is here to stay, and we need to know how to deal with it correctly. I mean, I've had staff people ask me, Bob, am I going to lose my job to AI? And my answer has been no, but I'm told by smart people that jobs will be lost to people who don't understand or know how to deal with AI. So, Pam, you wanted to say something here?
Yeah, first of all, what was the results of the last question? Was it 87% said before
87%,
time you could put
87%
up the slide?
were in favor of B, and that was to investigate the tools, privacy, storage, and its policies to obtain, and if that need be, obtain client informed consent. Or C, only use the tool if if there's a guarantee of no retention of the client's materials. That was 12%.
Right. So the question I have, and to be honest, we have hundreds and hundreds of questions coming in. So I don't know if you guys answered this, but many are asking that if a law firm is using AI and inputs a client's medical records or other confidential information without telling the client, or maybe by telling the client, is that violating a client's right to privacy?
It depends.
It could,
You
right, it
probably
could.
need to talk to the, you need to
All
talk,
right,
you probably need to talk
let's
to
start. Let's go start with Professor. We'll go down the line.
Find a
Professor,
bunch of questions there from people.
go ahead,
So it
Professor.
depends. I think the biggest problem is if you use, again, ChatGPT or something where you don't have strong confidentiality protections in place, this is going to be a problem. But more and more organizations are setting up private AI tools. And if you have something like that, then when you put that medical report in the cloud, let's say, well, that's where your AI tool is going to reside. And if you have sufficient guarantees from Microsoft, let's say, that that information is not going to be used to train an AI tool or otherwise disclosed, then it shouldn't be any different than the document being stored in the cloud that you could use that. But you've got to make sure you've got that kind of a setup in place to protect the confidentiality of the information.
Mark?
2 points. One, exactly right. I agree with Professor Linda. It's about reasonableness. We've been looking up confidential research for legal research for decades on Lexis and Westlaw. It's the same thing. It's just a different medium. 2, this is why you need to update your engagement letters. All of you, when you're done with this, go back, update your engagement letters appropriately. And again, the ARDC has a little helpful guide in the back that gives some templates to help you do that.
And that is so important about taking a look at that ARDC website. It's so helpful. Judge Camille, you're next, and then Judge Wilson. Then I'm going to tell you guys what's going on in the real world.
Okay, well, I wouldn't, go against my friends here, but what I will say is where I think we miss an opportunity. Yes, you shouldn't put anything that has personally identifying information, but you could, if you could redact the name or the detail that ties those medical records. That's where potentially I think you can use some of these tools. And that's where I think maybe it's just laziness, haste that we've talked about already, sloppiness, whatever you want to call it, Bob. But, if I'm putting, okay, I gave something up, but, I have this disease with these elements, I think you can search that. But otherwise, yeah, I do agree. This is a challenging area.
Judge Wilson?
I agree. Even with a client waiver or consent, I would not upload with personal identifiable information in any of these models. I believe that's going to backfire on you. And even if you escape any malpractice lawsuit, look at the damage that it may do to your client. And so, as Judge Camille said, you need to redact if you're going to do that. You need to make sure that any personally identifiable information is redacted before you do that, even with client consent.
One quick comment on the redaction, if I may, is that
Yeah.
I think what we're seeing is with more and more powerful computing and the ability to connect data to other data sets, even with redaction, we have to be careful because I'll hear people say, well, I anonymized it, but there can be other traces of data that can somehow be linked to other data. We're seeing this come up in other places, and we'll see it come up in the law space where even if you think you redacted what's sensitive, it could potentially be linked with other data to reveal the identity of people. You just got to be careful if that's the approach to take.
Well,
Dan, that's why I said personally identifying information, right? Because it could be something that's unique to the person. I agree with you.
Well, here's the thing. Here's what's going on in the real world, okay? there are companies, whether it's vendors, whether it's a group of doctors from India or a group of nurses from Indiana, who are marketing their services to create medical summaries for the lawyers to use in prosecuting injury claims, whether they're car crash, building blowing up, medical malpractice, whatever. And so what the mechanically what happens is you enter into an agreement with this vendor. You transfer the client's medical records to them. They create a summary, and you use that summary to network with your experts and to determine, let's say, the nature and extent duration of an injury, or you'll use it to talk about whether there was or was not a deviation from the standard of care. And my query to you is, how is that any different than any other work product tool that I use? Okay, to if I hire an outside expert and I give the outside expert the material, it's the same thing. He or she's gonna create a summary for me. How is there any difference there? You guys are inferring that the minute that I give this to Thomas Reuters AI tool, they're marketing. Where's Sonia? Sonia, post on the thing. What was the joint today? They wanted to buy free lunch for everybody in the office so that they could come and tell us about their AI tool. I mean, you hire these people; they're outside vendors. How are they any different than an expert witness that you hire to review the same material? Come on.
You still have to be, you have to be just as
the real world. Lawyers can't. You talk about saving time. Can you imagine going through a 2,000-page medical record and redacting all the information that identifies the client? Give me a break. That's not going to happen.
You have to have the same.
Thomas Reuters co-counsel wants to take all of you to lunch. Okay, go ahead.
You have to be just as careful in those situations. Suppose it's hacked. Suppose they're not connected to the cloud or anything, but their data is hacked. Hospitals and all these records are hacked by outside saboteurs. You have to be careful. You have to know what you're getting into. You have to know their standards and their security of their systems. I don't think it's any different. You still have to be careful. The problem is lawyers, especially, who just say, here, get it in. Oh, this is the new latest and greatest hot thing here. And they're not thinking about, hey, I've got to treat this the same way and operate the same way as I was doing it before. I have to be careful.
But answer my work product question.
Well, there are ways to address. I was just going to say there are ways to address retention and privacy and all of that, depending upon the tool. But Bob, I think the big difference is when you're using this tool, rather than having one of your fancy pants doctors come into your office to look at this stuff, here you're putting this stuff on either the World Wide Web or a respective called large language model that Thomson Reuters or some other entity might have that might have or give access or allow access, however you want to phrase it, to some other entity. That's the difference, putting it into that forum.
Mark, what do you say?
I will say that
Dan,
I just want to say that, Bob, I think you're ahead of your time because, my prediction would be that that's where the law will go over time, because I think the concern we have, it's like the early days of the cloud, like, oh, all these risks and all these things that could happen. And, I have a personal chat with ChatGPT and suddenly everyone on the internet can see what I talked about. The chances of that actually happening are very low, right? Because those sort of disclosures are unlikely to happen. And I think we may get to a point where we say, there is a reasonable expectation of privacy that when you use these tools, especially if you have certain settings set the right way, or even would be okay that the actual realistic chance of disclosure is incredibly low in those sorts of situations. But it is a little bit different. One person who signs a non-disclosure agreement or agrees to maintain it as confidentiality versus loading it up to a big tech company when it could potentially go to millions. That's where we are now. So,
I know lawyers. In fact, I was going to ask Judge Camille this earlier and Judge Wilson. I know lawyers who right now are using ChatGPT. Here's what they're doing. They're identifying all of Judge Camille's reported writings, and they're running that through the ChatGPT, And then they're saying, okay, I've got this argument coming up in front of Judge Camille. What's the best way for me to argue this to him that will resonate with his previous written orders? That's what's going on in the real world, you guys.
Well,
Not a
we have a
problem.
question here, Bob, and for all the lawyers on here and judges. Do I have a HIML obligation if I have information, Donald is asking, that an attorney misused AI? Is there a HIML
What's
obligation?
misuse? What's
Well,
misuse?
Exactly.
there are always, as I was coming along about to take the bar, the rule was rat on your friends and be available to testify. So if you know or have information that they are violating the rule, not potentially, but violating the rule, then yes, you have that obligation to turn them in.
All right. I've created enough disharmony here. I got to get on to number 9. Okay, Pam, hypo 9. A paralegal in a small firm eager to help uses a free AI summarization service to speed up brief drafting. The attorney only finds out about this after noticing stylistic changes in a filing. The firm has no written AI policy or approval process. I made a note to myself, where do you get one? All right, now here's the polling question. What is the best ethical protocol for the firm? A, allow staff to experiment with new AI tools without oversight to encourage innovation. B, require firm-wide written AI SAGE policies, mandatory review of tools and training for all attorneys and non-lawyers. C, ban all AI use to avoid risk altogether. Or D, only review AI use if a problem or data breach arises. Holy cow. So what do you think about that, Judge Camille?
Oh, obviously it's B, or at least I'll say obviously. And I'm proud to say, I have one of my externs, Sylvia Tolchik, zooming in with us here. And what Sylvia, I think, will tell you, I hope she reminds, when I bring an extern on, we sit down, I talk about the judicial candidates. Hey, what's beholden to me is beholden to you. I even put it in writing. Same thing here. It's your oversight. It's your policy. It's everything that you do to serve the client. And I had this happen when I was a law clerk, and when I had my law firm and was in private practice, did the same thing. Because yes, we are responsible, Bob. So to me, it's B. It's clearly B, and it's a good practice pointer or reminder.
Yeah, well, Judge, you're spot on. 98% of the participants today agree with you. I'd like, Mark, is anything that you could add to that?
No, I'll be my broken record again. Policy, governance, and enforcement. So be sure you're not just putting that written four corners policy up in front of all your employees and staff. You're going beyond that. Your action items on that policy. You're engaging with it. You're setting up guardrails. You're training on it. That's what's important.
Do you know of any location? I mean, does the ARDC have something like this where a law firm could download, material that they could then have an in-house, luncheon with all of their employees and lawyers and talk about AI policies that they're going to adopt or have adopted? I mean, is there anything like that out there that you're aware of, or is there a source out there for something like that?
Well, Bob, what comes to my mind is the policy itself can come from entities like the ARDC. That's great and should be, governed by other ethical lawyers to give advice. But the vendors then are going to be happy to help train you on that, and hopefully that should be part of the process. But don't just rely whole cloth on what they're saying, of course. You need to back it up with your own evaluation, and that comes with your competency requirements as a lawyer to at least understand that and have a basic review of it. And I also want to point out, there is that clear wrong answer of banning all use or the clear wrong answer of allowing for experimentation. But, it is important to roll up your sleeves and practice with these tools. Do non-legal things with them as well. Get to know them because they're very different than what we're used to. They're not like an internet search, a Google search we've done for 20, 30 years plus. This is an entire new creature that you converse with, but it puts out outputs in a whole new, unique way. And once you understand at least basically how it works, that'll help you develop the policy, and have the proper training.
Well,
Okay,
we have
Bob.
a question here, is
Bob-
AI capable of rewriting the rules of attorney professional conduct so that there would be, it could be more simple, clear, more consistent? Is that possible? Mark?
Anything?
I don't
Okay.
think we're going to see many rule
Bob?
changes specifically, but I do think we're going to see some evidentiary rule changes tweaked. I think it's going to start on the federal level first of a couple changes of digitally created evidence. I think we're going to see that go down quickly to the states, including Illinois, after that. I think that's an important update to our profession, more importantly, the quality of justice that we evaluate from the bench.
Mark, are you aware of anything by the Federal Rules Advisory Committee right now on doing anything about that?
I'm on the actually the Supreme Court Evidence Committee, and this is already on our radar, and to start getting public comment and stuff with respect to these issues. And with respect to the ARDC, if you go to their handbook, page 22, they talk about how to set up policies in your firm with respect to AI usage. And so, yes, you want to take a look at that. And I've even, as I've done some of these presentations and prep, you've uploaded documents and say, use this document, summarize the three main points, and yada yada, and you really get a good product. You'd be amazed at what you get. So these are, I think, good tools to use with proper supervision and oversight.
Okay. All right, guys, we got to move along. If you don't forgive me, we have 3 more hypos and only about 20 minutes to get them in. Forgive me for moving us. I'm sorry I had us talking too much. All right, hypothetical number 10. A law firm represents Big Co in a $200 million acquisition of Small Co. Big Co insists that law firm use a well-established AI due diligence tool. Big Co says that using the AI due diligence tool will result in faster and better due diligence and reduce lawyer fees. Big Co provides law firm with information showing that the AI due diligence tool is accurate and reliable. After Big Co has engaged the law firm and when due diligence is about to begin, the lead lawyer tells Big Co that in his judgment, it would be a violation of the rules of professional responsibility to use AI. The Big Co general counsel is furious and directs the lead lawyer to use the AI tool nonetheless. Okay, interesting. What best states the lawyer's primary obligation at this juncture? A, the lawyer must use the AI because a lawyer shall not charge an unreasonable fee. B, the lawyer per Rule 1.4 was only required to consult with the client and communicate the lawyer's decision that AI would not be used. C, if the use of AI would violate the lawyer's obligations under the rules, the lawyer cannot follow the client's direction to use AI. And D, if any of the underlying information is confidential, the lawyer cannot use AI for due diligence. Professor Dan, what do you think about these things?
Well, I think the main thing we're trying to get across here is even if your client is really enthusiastic about using AI, if you think using it would violate your obligations of the rules, then you cannot use it. It wouldn't be acceptable in a later malpractice lawsuit or appearing for a judge if there was a mistake, for example, to say, well, my client said I had to use it. It's on you. You have to exercise your independent judgment. And I think the other thing that this brings up is this idea of consulting with the client. And, the rules aren't always so clear the extent to which the lawyer can just completely choose kind of how to get the job done. But particularly as some of these tools are being introduced, I think there's going to need to be more consultation with the clients and having a discussion about how the work is going to get done, particularly in a case like this where you have a sophisticated client, a lawyer also inside of the company that's talking with you about how the work is going to get done.
Yeah, well, that's kind of my thing. You got a sophisticated client, you got a big law firm. I mean, I would think that the lawyer is going to follow what the client wants. I don't know. But Mark, what do you think about this one?
No, you got to be careful there, Bob. Just because the client is sophisticated does not waive this recommendation or this requirement, I should say. And that can be difficult for a lawyer to make that decision. I get it. But Professor Lena used a word there several times, and that was how. How the lawyer controls the how. The lawyer controls the means. The client controls the why, the objectives, right? That's why they're there. That's why they came to your office or picked up the phone or reached out to you. But the lawyer controls how you get there, the means of doing that. And if it violates the rules, it's a hard no.
I had cases in Chancery where the lawyer was saying, but it was a sophisticated client, and the client is saying, yes, we're sophisticated, but the lawyer still had their own duties and responsibilities.
Yeah, Judge Camille, I see you. Well, you're shaking your head for a moment. You're shaking it the other way.
Yes. I mean, Bob, I can't believe we got what's it? CYA always, and that's some of this. But yeah, it's the real world, like you say, the real world.
Yeah.
I agree.
We don't have a polling percentage on this one. I guess there's a lot of confusion about what the deal is, right? So, Sonia, do you have a polling position here?
Well, Bob, I think you respect the client because you're there to help the client. I'm not going to say we're just a mouthpiece or a functionary, a lot more than that. I agree with my colleagues here, but I think we have to follow the client's direction. It's his or her or its case, but then we also have to be cognizant of our responsibilities to the practice, to the rules. I agree.
Yeah, it just strikes me as that where's the line between the client hired the lawyer for a reason, and where's the line drawn between, listen, client, you're either going to listen to me or you're not. And if you're not going to listen to me, then maybe you ought to go get another lawyer.
Right.
At some point, maybe have to do something like that. And by the way, 83% of everyone say that if the use of AI would violate the lawyer's obligation under the rules, the lawyer cannot follow the client's direction to use AI. That's an interesting one. And 11% said B. The lawyer, per Rule 1.4, was only required to consult with the client. See, so there's a lot of pushback from the bar here on what the client wants. I mean,
Bob, I think there's a really important point here, though, and that is that, too many lawyers are skeptical about these tools and whether they can help, but there are some lawyers and some clients who are too optimistic and enthusiastic and don't understand the risks either. So the bottom line is you have to exercise your independent professional judgment as a lawyer. If the client is really enthusiastic, you can use AI to do this, this, and that. You still have to exercise your independent judgment and be confident that the tool can do what the client thinks it can do before you rely upon it for that.
There you go. There you go.
We'll see how this works out. Okay, go ahead.
Go ahead, Mark.
Just one step further is that once you do agree to use that tool, then you need to memorialize how you evaluated it. How did you apply the reasoning it gave you, whether you accepted it or declined it at the end of the day. Document the process so you can rely upon it and do those spot checking and audit along the way it goes. Don't just blindly rely on it, of course.
Yeah.
We'll see how this works out. We'll see how this starts to work out in states that start using letting non-lawyers own legal enterprises and firms. So we'll see how that works.
Oh, there you go. Okay, we don't want J.P. Morgan Chase buying your law firm. Is that what you're telling me? There we go.
Some states are starting to allow that model because of lack of lawyers in certain areas. So we'll see.
My one friend Eric says MMPA applies. This bot would be putting liability for a firm. There you go. Interesting. Okay, these are good things. All right, we're moving right along here. We got 2 to go, and we have time. And this is my favorite one coming up here because I had to ask for explanation of this, but I think this one's pretty good. I thought of Judge Camille on this one. Here we go. So attorney number 11, attorney Sam Bam Bam Winner is a well-respected criminal defense attorney. And at his favorite watering hole one day, he regularly brags that he started practicing law before the advent of computers and has very little use for them and this newfangled technology. And he believes AI is a scam, and he can sniff out the use of AI like a bloodhound. Well, then he goes to court, and he attended a bond hearing for a new client. And the young man was Jay, a 19-year-old African-American high school senior with superior grades and impeccable manners. And despite their professional careers and income, Jay's parents believe that staying in the community they grew up in is important, despite how rough it has become. At the hearing, the judge asked for the risk assessment It was not good. The judge set a high bond. Now, for further context, folks, I asked about that, and the risk assessment was ordered by the court, paid for by the court. I believe Judge Wilson will correct me if I'm wrong. And so it's a tool that the judge used and relied on in establishing the bond. So here are the hypotheticals. What went wrong here? In other words, super high bond and is a really good kid. Why did that happen? Comes from a great family. A, the lawyer did nothing wrong. He represented his clients competently, but the risk assessment just wasn't in the client's favor. This hypothetical has nothing to do with AI. Or B, the lawyer has a competency issue because he did not realize that bond risk assessments utilize AI since algorithms, assumptions, and data. And then I added a C on my own. The judge should have disclosed that he's using a risk assessment that was based on a use of AI, so the lawyer could have done a better job of helping the young man to get a lower bond. That's so. Judge Wilson, tell us about this one because you knew all about it.
Yeah, so you have lawyers who say they don't believe in AI. I'm staying away from AI, and maybe you don't understand that AI is everywhere, and maybe you don't understand that in creating these risk assessments for setting bond, there are large language modules that are being used or have been used, and they have assumptions. They have sometimes bias baked in. And this was a big thing. Some states had to, even though the court is using these tools, they had to redo the tools to try to take out some of the bias. And there are articles, by the Bail Project about risk assessment tools, racial equity, and in criminal justice based upon risk assessments. And so just because you're not using an app doesn't mean that you're not using our AI. And so you have to be aware that AI is baked into so many other things, and these large language modules and algorithms that are used can sometimes be biased. And in this case, the bias was because it used data and assumptions about neighborhoods and income. And just because that family happened to live in that neighborhood, it did not accurately reflect them because it had some biases built in. And so that's the point of this, that you can't escape AI. You still have to know what's going on.
Okay.
Yeah, and Bob, I'll just add on to what Justice Wilson said. I think this goes back generally to the issue of competence, like it or not. This is a tool that I think whether we like it or not, we more or less have to embrace. And I suppose it's okay if you didn't, but I don't know if you're giving your client the best that you can possibly give your client. There's a lot there's a lot discussed in the trench in the criminal world and the juvenile justice world about recidivism and trying to give the person to be sentenced or however you put it to give him or her the best chance. So a lot goes into that, but I think it goes again back to competence, and then not only competence, like I said a little earlier, with my loved one. Sometimes if you use these tools, you may not get anything else, but you might get something that helps. In this case, get the kid on the path that the family wants him to be on.
Well, I tell you where the rubber met the road for me on this one was in the idea. I mean, here I don't do any criminal work of any kind and never done a bond hearing, so I had no idea that the courts use a third-party provider on risk assessment. Okay, but what would be different? I try cases all the time. I've been in federal court now, almost once a week. And how do I know that the judge isn't using AI to write a legal opinion or an order against me on something? Do I have a duty to be asking about that?
Okay, I'll tell you what I tell my externs, Bob. I expect them to use AI.
Yeah, well, maybe I should be asking. In that ruling, that bad ruling you just entered it, I want to know if your clerks used AI.
No, I want
Well,
them to use it, right? I want them to use it because I want to. Then they give it to me. Then I might, massage it, and that might not look like when they gave it to me, but I want to see what they got. And then we
well,
also use AI to review pleadings. We do. Anyway, I'll shut
Bob,
up.
you don't need to know.
Are we going
Yes,
down that road, Thaddeus? Judge
Bob,
Thaddeus?
Bob, you don't need to know whether or not they use AI. That's not the issue. That's not going to help you in any way. When a judge issues a ruling, you don't like it or question it. Guess what you do and supposed to do? Research it, read it, look at the cases and the reasoning that the judge used. That hasn't changed. And so I was on a panel and someone said, "Well, I want the lawyers, I want the rules to change so the lawyers tell me if they use AI." What difference does that make? How does that change the way you do your job as a judge? It doesn't. You're still supposed to read the materials, read the cases, and see if it is up to snuff. So you don't need to know if the judge used AI.
I understand there's an AI tool out there that if you submit a written something to it, it can tell you whether or not, on a high level of probability, it was written by AI. Did you know that? That's out there?
Yeah.
No, that
Yeah.
should be debunked. Because the research that I've seen and is that those tools are not all that accurate, and they shouldn't be relied upon, and they're easy to evade, and worse yet, they're biased. Right. So if you're a non-native speaker of English, for example, much higher likelihood of a false positive. They're coming out with more and more tools to try to detect some of this, and some of them might have a little higher of a level of accuracy. But every study I've seen so far suggests we should be very skeptical if those tools can accurately predict, and we should be very skeptical of humans who think they can accurately predict if something has been written by AI as well.
All right.
There,
So,
there
so
are some
the
tools.
majority of the opponents, the attendees rather, the majority of the attendees thought that there was a lawyer competency issue here because the lawyer didn't realize, like me, that AI assessments utilize AI. So there you go. Stay in your lane of traffic is the moral of that story. Okay, let's go on. Judge, I interrupt you. You got something else that you wanted to add? Otherwise, I'm going to the last one, number 12.
No, we can go on.
All right. Hypothetical number 12. Manufacturer engages lawyer to go to federal court tomorrow to file a lawsuit and a motion for an ex parte temporary restraining order and preliminary injunction ordering the supplier to continue supplying rare earth elements needed for various products. The supplier contends that it is no longer bound to perform under the contract as obtaining rare earth elements has become commercially impractical because of international trade negotiations and disruptions. The manufacturer directs the lawyer to retain an expert to provide a declaration regarding the declaration with numerous citations to academic research and news articles regarding the market for rare earth elements. He suspects the use of AI. What best states the lawyer's primary obligation? A, lawyer has no obligation to verify information in an expert's declaration. B, the lawyer under Rule 5.3 has a duty to supervise the non-lawyer expert. C, the lawyer under Federal Rule Civil Procedure 11 has a non-delegable responsibility to validate the truth and legal reasonableness of all papers filed in federal civil litigation, which extends to expert declarations. And D, the lawyer under Rule 2.1 must respect the independent professional judgment of an expert. Or I'll tell you, E, they've never worked with Shannon McNulty, my partner, who would have had it in 90 minutes, not 2 hours. Okay. So, all right, Judge Wilson, what do you think about this one, sir?
I'll leave this one to the professor, but I think again, supervise. You cannot delegate your responsibilities, and so again, you don't get off the hook by blaming it on the AI.
So I think
Okay.
we're picking up on a case out of the District Court of Minnesota on this one, Coles v. Ellison, and there was an expert witness from Stanford who filed a report that had hallucinations in it, and the topper of this is that the professor is an expert in misinformation. and had the hallucinations. But the court had this line in there that there should be an inquiry reasonable under the circumstances that's required by Rule 11B, and that may require attorneys now to ask their witnesses whether they have used AI in drafting their declarations and whether they have done anything to verify the AI generated work. So I can't say that this is a hard and fast requirement right now, but at least we have this case and maybe others that are suggesting that you should be aware of and taking a look at what is in expert reports and declarations, and perhaps asking them directly, did you use AI to create any of this? I bet that there's going to be division in the courts on some of that.
And I go back to my original question, and what's illegal about any of this? I mean, if the report that was generated in a 2 hours period of time is substantively correct, it has no hallucinations, all the material is citable, findable, quoted correctly, well, help me out here. What's the harm? The judge, Mr. Palmer, Mark, you were shaking your head.
Well, I mean, Bob, a broken clock is right twice, so there's very good possibility there may be correct elements to this, but that doesn't change your responsibility to review it and inquire about the process and how it was done. And you better do it because if you're bringing it to trial, the opposing counsel is going to be all over it, right?
Well, I think there's 5.3. Lawyers don't focus enough on 5.3. We were in our discussions, we talked about that. What are your duties regarding the assistance you're getting from a non-lawyer?
Because in the case that the professor brought up, I mean, the lawyers really would be just blindsided. Here we're talking about an expert who is the expert with supposedly about AI hallucinations. I mean, it was just truly unbelievable.
Gary says from Kansas, because we have many states involved here, that the Kansas Supreme Court requires certification for all filed pleadings and motions as to whether AI was used in the preparation of the materials. So some states are, I think, moving toward that.
Unfortunately.
Well, on that point exactly, and I think some on this panel know very closely because we're involved with developing and helping the Illinois Supreme Court develop its policy saying that disclosure is not a requirement in Illinois. So you can use it, but it's just so difficult to begin to define what even is artificial intelligence or generative artificial intelligence, because you can't do an internet search or open a Microsoft product this day and age, and you're automatically using AI to some degree already. So where do you draw that line, and how do you define those terms to begin with? It's just too difficult.
Yeah, do I need to know
the majority of our audience, the 80% believe C is correct, that under Rule 11, the lawyer has a non-delegable responsibility to validate the material. Judge Camille, you were going to say?
No, if I was a lawyer, I'd want it to be D, but C, I think is the right answer. And, another practice pointer, Bob, you hate to say it, we've talked about the engagement with the client, engagement with experts. You got to be careful. Like you, we all probably, when I was in practice, you'd hire somebody, a person you've trusted for years. And we might also have some horror stories, right? But, with all this, you probably have to be very careful in that regard.
Now, in terms of changing the rules, why do I need to know that a lawyer used spell check or Grammarly or Copilot, anything? What difference does it make if you use the dictionary? You got to tell me that? No, the rules, in my opinion, are sufficient as is. We may need to have more in terms of comments to help lawyers and guide lawyers, but I believe the rules are sufficient.
But Thaddeus, I think you would agree. Some I worked with Dan, if you remember Dan, when I was adopting a policy out here as chief, and we didn't put it in there, but I know some of my colleagues wanted it in there, and I think that's probably throughout the states and the country. And I agree with you, Justice Wilson. Yeah, it's a tool.
Well, I can't help but think that this is a call to arms for the bar. That, ladies and gentlemen, you're about to get hit with a bunch of rules regarding AI that if you don't pay attention to them and maybe weigh in through your bar associations and any opportunity you have to attend open forums that the court or the rulemakers might have, we might be stuck with some rules that you're not going to be too happy about. Pam?
Yes, I'm sorry I didn't get to hundreds of questions, but as a final one, as we close the program, do the panelists think that it will soon be an ethical violation if attorneys don't use AI to check their pleadings or their research?
Well, let's take it from top to bottom. Professor, Lena, and then Mark and Judge Kamel, and finally Justice Wilson. What
Yes.
do you think?
You should have a policy inside of your firm, and one of those policies should be before anything gets filed with the court, you run it through technology to check it for hallucinations, and you should be using AI and other ways to improve work product as well.
Mark?
It goes to the word relevant. You have to know the risks and benefits of relevant technology under 1.1. What is relevant to you? We saw what it was relevant to a criminal lawyer just a bit ago. What's relevant to Bob in his practice doing massive airline crashes? Very different, right? So it's relevant to you.
And I'll cite Rule 1.1, competence as well. If you're gonna handle cases, whether it's in my courtroom, Justice Wilson's courtroom, or anywhere, even outside of the courtroom, you got to be competent. Otherwise, don't take the license that the Supreme Court blesses you with. Thank
Justice Wilson.
Yeah, I don't think it in terms of misconduct, but again, competency. Just like my example, would you use the lawyer who says, I only use the books, I don't use Westlaw, Lexis, or other online tools? That doesn't mean that they're committing misconduct, but it definitely has caused them to question their competency.
All right, and I want to have the last word on this by saying I dissent from a lot of what I just heard. I think it's hard enough now practicing law, and we put more and more stuff on the shoulders of lawyers. Let's let these rules slowly percolate and give the bar a chance to be responsive to them before we make it any harder to do this work, okay? And on that note, I think we are finished for the day. Pam will officially end the program, but I want to thank you panelists, Professor Lena, Mark Palmer, Justice Kamel, or Judge Kamel, Justice Wilson. You guys have been wonderful, and I'm very grateful, as I know all of the people listening today are, for your participation, your expertise, and your words of wisdom. Thank you all. Pam?
Yes, and that does conclude thank you, Bob. Concludes today's presentation from the War Room to the Bench, Navigating AI in the New Legal Frontier. A link to the CLE certification process will now appear on your screen. Please take the time to request your certificates as soon as possible. This link also will be emailed to you tomorrow morning. On behalf of all of us here at Clifford Law Offices, thank you for joining and have a very safe evening. Thanks for coming. Good night.
Bye, everyone.
Thanks, everyone. Bye.
Thank you.
you.
Bye now.
All right, ciao.